Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that's been getting a lot of attention in the news, and most of that coverage has been negative. There have been several opinion pieces written talking about how the Supreme Court is throwing out mandatory minimums based on imaginary scenarios. And so a fair number of people have reached out to me. A lot of people are upset or angry. And I wanted to cover this case to provide a bit more detail, because while there is some truth to what's being said, there's also a lot of context and a lot of rationale that's being left out. And I think that it's important that we have a more complete understanding of this one. So this is the case of the King and Hills. And what happens in this case is that Mr. Hills pleads guilty to a number of offenses, but the critical one is a charge of intentionally discharging a firearm into or at a place, knowing that or being reckless as to whether another person is present in that place, contrary to section 244.2 sub 1 sub a. So what he did is he had a hunting rifle and he shot at a car as well as an occupied residential home. That, of course, means that Mr. Hills is a bad guy, right? This is kind of serious stuff. And at the time, this offense carried a mandatory minimum sentence of 4 years in jail. Now, I say at the time because the Supreme Court has struck this down. So you might say, why would they do that? Well, Mr. Hills, as I mentioned, he pled guilty, but he also brought an application to say that this was an unconstitutional mandatory minimum. And the reason for that is not so much his circumstances. However, he's bringing an argument based on a reasonable hypothetical. And the reasonable hypothetical is an imaginary person committing an imaginary crime, but the same sort of crime, and basically pointing out that in a reasonably foreseeable circumstance, this mandatory minimum would result in a punishment that was sort of grossly unfair. So you might be saying, why is this something that the court's going to consider? Why are they going to listen to this notion of this kind of imaginary person? And so we can go back and look at a previous case that applied this. And I covered that case as well. And that's the case of the Queen, as it was at the time, and Nur. Now in Nur, there was a different mandatory minimum that was at stake. It was an issue of possession of a restricted firearm together with ammunition. And the punishment for that, there was a mandatory minimum at the time of 3 years in jail. Now, Mr. Nur was also not a great person. He was he was involved in criminal enterprises and not exactly the greatest candidate for being cut a break. However, the Supreme Court looked at that case and they said, listen, it's the punishment that was given to Mr. Nur, which was above the mandatory minimum, is entirely appropriate for Mr. Nur. We're not going to give Mr. Nur a break on this one. However, we are going to declare that the mandatory minimum itself is unconstitutional. And the reason why was not because of Mr. Nur's circumstances, but because of the circumstances of how that law might apply to someone else. And in particular, this is one of the few cases where the Supreme Court was kind of looking out for the ordinary law-abiding gun owner, specifically somebody who might have let their firearms license lapse. You know, if you've got, ammunition because you go to the range and you target shoot and you just forget to renew your license, the question is whether or not that failure to renew your license when you still have the guns and you still have the ammunition is worth 3 years in jail. And the Supreme Court said, obviously not, right? That makes no sense, because at that point you're talking about somebody who's really committing more of a paperwork violation. They're not, selling those guns to criminals. They're not, using them violently. It's just they forgot to send in their paperwork. That makes a lot of sense, right? It seems that it would be unfair for somebody to be punished in that scenario. But there was a lot of argument in the case of Nur because the Crown, the government, was saying, listen, you haven't actually shown that anyone has faced that 3 years in the circumstances you're dealing with. But the court says, listen, just because nobody can show that that's happened yet, that doesn't mean that it hasn't, because of course it's really hard to find out what cases have happened definitively. And also they say, if this is open to abuse, it will eventually be abused, and why do we need to wait for this? The Supreme Court typically tries to deal with sort of broad spectrum decisions. They're trying to sort of settle an issue for, once and for all. And so it makes sense to have the Supreme Court kind of evaluate the larger questions on that one. So that was the case of Nur. Now, based on that reasoning, the trial judge in Hills says, I don't think that this is an appropriate penalty. And the reason why is, again, based on this reasonable hypothetical, which in Hills was the circumstance of somebody using a pellet gun or a paintball gun. And they actually brought an expert in to say, we built sort of a fake wall for a house, and we shot, a pellet gun, we shot BB guns, we shot air rifles, we shot paintball guns, and most of these can't penetrate through the wall, and therefore there's no danger to the occupants. So based on that, if we, envision the scenario of somebody shooting a paintball gun at a house, it seems a little unreasonable to charge them, to have them face 4 years in prison. So on that basis, the trial judge threw out the mandatory minimum and sentenced Mr. Hills to 3.5 years. So the Crown appealed that decision, and they said both that they thought that the determination that the mandatory minimum was unconstitutional was a bad decision. As well, they thought that Mr. Hills got too light of a sentence. And the Court of Appeal came out very strongly on this one. There were multiple decisions on this one. The most strident of them comes from Justice Wakeling, whose decision I'm not going to go through bit by bit because I might have to appear in front of Justice Wakeling again, and, he's in my area. I don't think he'd appreciate my commentary on his decision. But essentially, it comes out very harshly to the Supreme Court and the reasonable hypothetical model. It says essentially that, we should be evaluating this for each individual offender, and that it's very difficult to call any term of prison cruel or unusual, which seems a little strange because we normally would think that, for instance, if somebody jaywalks and we're going to send them to jail for 20 years, that would be cruel or unusual. But he disagrees with that. And ultimately, he finds that the sentence that was assigned to Mr. Hills was unfit, and so it gets raised to 6 years. So the Court of Appeal says, nope, this is not an unconstitutional punishment, and also Mr. Hill's sentence is going to go up. So on this goes to the Supreme Court. And keep in mind, the Supreme Court just fairly recently reaffirmed the reasonable hypothetical model. So you kind of have to suspect that they're going to continue with that. But that's sort of our first question is, are we going to keep using the reasonable hypothetical model? I just kind of want to look a little bit further at the reasonable hypotheticals as well, because the Court of Appeal in Alberta took issue with the particular hypothetical. They said, well, what happens if you shoot at a window? Or what happened, how do you know that this paintball isn't going to cause, some sort of real injury if it goes through an open window? Now, I think that that at the sort of trial level there, they could have done a better job with the experts. And I'm not criticizing too harshly because ultimately they win, right? But there could have been some further discussion, I think, about the kinds of things that count as firearms. And in particular, they're looking at what I'd call 84 sub 3 firearms, which is that in Canada, the definition of a firearm is anything with a barrel that fires a projectile that can cause serious bodily injury or death. So that includes, your standard hunting rifles, your handguns, all of these things that you would normally think of as firearms. But it also includes some stuff that you wouldn't, notably things like airsoft guns or paintball guns would be unusual examples. But we can go a little further and, because those were examples that were considered in the Hills case, but we can go a bit further and look at some more maybe unusual ones or just ones that they didn't think about. I have a previous video where I check out this thing. This is the Nerf dog ball launcher. You can see it's got a barrel to it. This plastic bit here retracts all the way and it launches this thing. It's designed to fire a tennis ball so that your dog can chase after it. Now, I was able to get this thing to puncture an eyeball, which is basically the test the court uses to determine if this thing can cause serious bodily injury or death. I didn't have to modify the gun at all. I did have to modify the projectile because the thing that I found that was able to puncture an eyeball is a tennis ball with an arrow stuck through it. But you can fire that out of this. It takes a little bit of hassle and so forth, but you can do it. And that was able to puncture an eyeball. So based on that, my conclusion would be that the Nerf dog ball launcher is a firearm in Canada. So the question is it worth 4 years if somebody comes up to your house and shoots a Nerf dog ball launcher at it while you're home? Even if you happen to have your window open and they shot you through the window with the dog ball launcher, it'd probably really suck, but I don't think it would be 4 years worth of bad. It would just be kind of unpleasant. Another example I'll give here, and this one is very clearly a firearm in Canadian law, is a nail gun. Nail guns have a barrel, which is typically a quite short barrel. But let's imagine that somebody comes up to your house while you're at home and stamps a few nails into your wall. You might be pretty annoyed because this guy is damaging your property. That's a mischief. But is that 4 years worth of bad? Hard to say. Let's say, some 21-year-old kid is living at home with his parents. They get into a fight, perhaps the parents say, hey, it's time to start paying rent. And the kid gets upset, walks out with a paintball gun and, uses it on a big windowless stretch of wall to write something rude on the wall. Writes the F word in paintball splatters. Okay, that might be annoying, but again, not really worth 4 years. So that's the hypothetical that the court is looking at. So the question, again, it's very clear that I'd say that it's very clear that those hypotheticals would say in those circumstances, the penalty of 4 years is too high. It's in that case, it's ridiculous. The question then becomes one of the approach the court should take, because there's two different models that we can sort of look at here. The model that the Supreme Court has been adopting, which again has some controversy to it, is to allow the court to look at that hypothetical scenario in order to make a decision as to whether or not that mandatory minimum is just valid at all. The other method that gets proposed is to say, listen, we've got to actually wait until that person gets charged for the nail gun situation or the dog ball launcher or the paintball gun. And then at that point, we'll evaluate it. Now, I think that the reasonable hypothetical model makes more sense. And there's a number of reasons. First, we're trying to look at whether that actual mandatory minimum is itself constitutional. And the question of whether it's constitutional, to my mind, means if it's unconstitutional for anyone, it's just unconstitutional. And there is some past precedent that I think is relevant here. One of those is the case of Big M Drug Mart. Now, Big M Drug Mart was a case about Sunday closing laws. So at the time, there was a law that said that businesses have to close up on Sunday. And the reason why is that they were trying to promote a Christian day of rest. But Big M Drug Mart is a corporation, and as a corporation, it has no religious beliefs. So one of the questions in that case was whether or not they could argue the effect of this law on people who might have different religious beliefs, in particularly Jewish people who might still observe a day of rest, but observe it on Saturday. And if you think about it, the effect of having to close down on Sunday is way worse if you observe a day of rest on Saturday, because of that observance, you have to shut down on Saturday. So you don't get any business on Saturday. And then because of the law, you also have to shut down on Sunday. And so at that point, you're out 2 days where everyone else is out 1. That's a rough scenario. And especially, with people who work, the weekends might be the day they go and run errands. So you're just out of the running entirely. And the Supreme Court said, yes, that's entirely reasonable to consider. And so if you think that the Supreme Court can consider the example of, the hypothetical Jewish person in evaluating Sunday closing laws, it makes perfect sense that they can also do so in evaluating these mandatory minimums. The next thing, as I mentioned, is that the Supreme Court, and courts in general, tend to prefer to answer questions sort of definitively. And so if we're looking at each individual person as to their specific circumstances, then what we end up with is a decision that only generalizes to that specific person and their specific circumstances, which means that the same issue as to whether or not this mandatory minimum is constitutional may have to get litigated over and over and over again. Doesn't it make more sense to just allow the court to consider the broader question and then come to a decision that affects a lot more people and gets you a much sort of clearer rule? I think it does. I think that makes a whole lot of sense. And you'd also hate to be the guy who was sentenced with this mandatory minimum if the court then later determines that it's unconstitutional 2 weeks down the road based on somebody else's reasonable hypothetical or somebody else's actual circumstance. So it makes more sense to be able to argue all of those scenarios in a broad sense. The other thing is that not everyone is in a position to bring a constitutional challenge. If these are expensive, they take a whole lot of money. In this case, in the Hills case, they hired an expert. They needed the expert in order to establish the things that got the court to agree with their position. And if experts aren't cheap. If that costs $10,000 to get that expert there, not everyone's going to be able to afford that. And so it makes sense for that question to be able to be considered in the scenario of the person who can, because otherwise you're going to end up punishing a whole bunch of people who simply can't raise that money in order to defend themselves. I think that's fair to accused people. I think it's fair to, in general. And the Crown, of course, can challenge it. They can contest that reasonable hypothetical. And they can say, listen, we don't think it's proper. We don't think it's right. We don't think it's appropriate. And, there's various ways that they can attack that. So all of these things, I think, factor in on this. And we can sort of look a little bit as to what counts as a reasonable hypothetical here, because the Supreme Court in Hills offers a little bit of context and a little bit of narrowing to say, this is what a reasonable hypothetical will look like, because they don't just want to sort of leave people without guidance. So I'll just bring that up here. The characteristics of a reasonable hypothetical include the following. 1, the hypothetical must be reasonably foreseeable. 2, reported cases may be considered in the analysis. 3, the hypothetical must be reasonable in view of the range of conduct in the offense in question. 4, personal characteristics may be considered as long as they are not tailored to create remote or far-fetched examples. And 5, reasonable hypotheticals are best tested through the adversarial process. So they note here that it must be reasonably foreseeable, and so that means that it can't be a far-fetched or marginally imaginable case, nor should it be a remote or extreme example. However, they also explain the reasonable foreseeability test is not confined to situations that are likely to arise in the general day-to-day application of the law. Rather, it asks what situations may reasonably arise. It targets circumstances that are foreseeably captured by the minimum conduct caught by the offense. Only situations that are remote or far-fetched are excluded. So, when we think about, somebody shooting a paintball gun at a house, is that sort of easy to imagine that could happen? Yeah, I've actually seen several cases of it. So it doesn't have to be the kind of ordinary day-to-day experience, but it has to be something that we can sort of see happening that doesn't require a bunch of weird circumstances. Reported cases may be considered in the analysis because sometimes something has actually happened. So if you've got a situation where something has actually taken place, that makes it a lot more likely to think of it as a reasonably foreseeable example. So the hypothetical must be reasonable in view of the range of conduct in the offense in question. And what they're really getting at here is that in some of the case law, they strained this to the point where their imagined case wouldn't actually make out the crime. So as an example, if you say, listen, it's unfair to have a mandatory minimum for smuggling drugs, because what if you didn't know the drugs were in the vehicle that you were driving? Well, in that case, that's not an issue of mandatory minimums. That's an issue of you're innocent of the crime because you don't have the mens rea. So in that, which is, the guilty mind, you have to know that it's there in order to be convicted. So why would we include that in our range of reasonable hypotheticals? We wouldn't. So they note, and I'm including this partially because I just really like the Supreme Court snark here. To be reasonable, the hypothetical must be tailored to the offense in question. It needs to involve conduct that falls within the relevant provision. The scope of the offense can be explored, and it is permissible to establish the breadth of the offense by reference to how it may be committed and by whom. However, straining each and every constituent element by fanciful facts is not helpful. Incredible combinations of bizarre behaviors tells a court more about the imagination of counsel than it does the true scope of the impugned provision. The total scenario must be reasonably foreseeable. I appreciate that. That's amusing. Personal characteristics may be considered as long as they are not tailored to create remote or far-fetched examples. And what they mean by that is that your reasonable hypothetical could include, for instance, somebody who's indigenous or somebody who's young or somebody who's old. And these might be relevant. In the case of thinking about, somebody shooting a paintball gun at a house, it might be useful to think of somebody who's like 18 and maybe not all that bright. It just sort of happens as you grow up that you develop a little bit more maturity. And that kind of seems like something that somebody immature might do. And so that might be reasonable to consider. But they also say you can't kind of assemble a Frankenstein's monster of all of the different things that you might consider, to have okay, so they're indigenous, they're young, they've got one leg, and they also just won the Nobel Peace Prize, and, you can't do all of that. That just creates a weird scenario. And so these provide us with some guidance as to what these scenarios should look like. And so you can't just use anything as a hypothetical. There's got to be some tailoring to that. and some specifics. Now, one other thing that's really worth really worth thinking about here is there's been discussion of like, this applies to a lot of our laws, that a lot of our laws can be captured by this reasonable hypothetical kind of approach. And the reason why is that our laws tend to be written really broadly. So when you think about assault, it includes everything from like me throwing like, I don't know, a crumpled up ball of paper at somebody, all the way to me punching them in the face. That's and that's without considering that assault with a weapon includes assault. It's such a wide range. And so if you're going to put a mandatory minimum, like if you said, we really don't like people getting into, punching each other, so we're going to put like a 7-day mandatory minimum. Does that make sense if I just threw a crumpled up ball of paper at somebody? The problem that we get to is that so many of these things cover such a wide range of behavior. And really, one of the things the court notes here is that a way for Parliament to avoid having these mandatory minimums struck down is to narrow the offenses, or perhaps to narrow what is targeted by the mandatory minimum. So in this case, the Supreme Court has struck down the mandatory minimum for shooting at houses. And when you think about the ordinary scenario of shooting at a house, it makes sense to have a mandatory minimum there, at least to a certain degree. It's a better place. And I'm not a fan of mandatory minimums because they tend to punish the people most who are sympathetic and who might be deserving of a break. But that's what Parliament was really aiming the mandatory minimum at, is, drive-by shootings and that kind of scenario, and not paintball guns. But because it's so broad, because it includes everything from, really like a heavy machine gun down to the Nerf dog ball launcher, if you're going to include all of that range, then maybe that mandatory minimum is going to be a little harder to defend. So if I was in Parliament and I said, listen, the Supreme Court has just struck down that mandatory minimum, we really want that to be in place. What I would do if I were the legislative drafter is to say, well, I'm going to write a new section and say, there's a mandatory minimum of 4 years that applies where this causes a serious, where this causes a risk of serious bodily injury or death to the person, to a person. That creates a new level of proof, right? Now the Crown has to prove that that particular offense, if they want to trigger that mandatory minimum, caused that severe risk. Are they going to be able to do it with the dog ball launcher? Probably not, right? If I'm shooting the dog ball launcher and it's bouncing off, the wall, that's probably not going to do it. But in the case of Mr. Hills with his hunting rifle, yeah, that would cover it. So the Supreme Court specifically notes this, and they say, thus, the wider the scope of the offense, the more likely there is a circumstance where the mandatory minimum will impose a lengthy term of imprisonment on conduct that involves lesser risk to the public and little moral fault. In those cases, the sentence is liable to capture conduct that clearly does not merit the mandatory minimum. This provides a very clear roadmap to Parliament for how to write laws that comport, that fit with the Constitution. And I don't think it's too hard. They're just saying you can't create these giant offenses that capture everything and then say, well, we're putting a mandatory minimum because some of those cases are real bad. They specifically give the example of NER, which I mentioned, was a real benefit to the gun owner who might forget to renew their license. And they noted that in that case, the court said that the issue was because the offense casts its net over a wide range of potential conduct, including violations that created little risk of harm to the public and were instead little more than licensing infractions. When you roll a licensing infraction together with serious criminality, it doesn't make sense to set a mandatory minimum based on the assumption that everyone who's doing it is a serious criminal. So they note the offense therefore caught on one end an outlaw who carries a loaded, prohibited, or restricted firearm in public places as a tool of his or her criminal trade, and on the other end, a licensed and responsible gun owner who stores his unloaded firearm safely with ammunition nearby, but makes a mistake as to where it can be stored. It's such a huge difference. And so this isn't the Supreme Court sort of telling Parliament that they can't set reasonable mandatory minimums. It's saying you can't just set these broad categories that are going to capture people of little moral fault. And I think that makes a whole lot of sense. The Parliament, the government could fix this tomorrow. I mean, assuming that they could act that fast, but the government could fix this fairly quickly to create that new offense. Just like I said, to say, where this causes some actual danger to a person of, death or serious bodily injury, then the 4 years is going to apply. Now it's up to now it's open to prove that additional thing. And we've narrowed the scope to rule out the situation where somebody's shooting a paintball gun that can't go through the wall, or somebody's shooting an airsoft gun. Once we exclude those things, once that cuts, once you tailor it to cut that stuff out, then your law's probably good. You're probably good to go. So, yeah, I hope that this has provided a bit more explanation. And if people want, I can go through I can make another video going through everything in detail. The reason why I didn't want to do that in this case is that it's 133 pages long. It's really a long case, and while I'm happy to do a deep dive and go through and look at sort of their reasoning in a lot of detail, this one's getting a lot of attention, and there's a lot of people with opinions, and not all of those opinions are great. So let me know if you want me to do the full-on deep dive explanation. It'll probably be like a 2-hour video, but I know some of you like those, so let me know. Otherwise, this one's about 30 minutes. Hopefully I've made the case that it makes sense the way the Supreme Court is doing it, and that this seems to be an entirely reasonable decision to me. It doesn't make sense to me that somebody with a dog ball launcher or a nail gun or a paintball gun or whatever would get 4 years. It just doesn't. Thank you for watching. I hope you found this interesting and hopefully have a better understanding of what's happening in our legal system. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, David Michaud, the CCFR and the Canadian Shooting Sports Association, at the $30 level, Sights and Arms Limited and Jane Babin Luxor, and at the $20 level, Mark, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge.